Such an exciting character to take on as an actor, and then like to have diary entries with so much, full life in them, and just the dynamics between Lily as a child, like, or as a teenager, are so full. Yeah, they're full. So being able to pull from those and to take that and then to work on that as an actor, like that would have already been my process as an actor anyways, is like journaling, or like, trying to maybe like write out my character's thoughts. And when you already have that in paper, that like creates a whole other just like mountain of juice for you to use as an actor. It's the best. It's so exciting. So yeah, I mean, it was like a double whammy, a Colleen Hoover book, working with you, or working,
And also, hey everyone, it's Katie from Without a Crystal Ball. Welcome back. Today brought a double dose of unfortunate news. One from the courtroom, the other from beyond its walls. Justin Baldoni just faced a tough blow in court. And separately, Blake Lively found herself on the receiving end of some disheartening developments too. Not every day hands out wins. Today was proof of that. Let's dive into what unfolded. Justin Baldoni, alongside his Wayfarer Entertainment team, including Steve Sorowitz, Jamie Heath, Melissa Nathan, and Jen Ale, had approached the court with a request. They needed more time. Specifically, they were seeking a 30-day extension to wrap up their discovery process. In addition, they hoped to gain extra time to revise and refile their complaint. This request came after a scheduling conference held back in February, which had mapped out the necessary timelines to keep the case on track for a March start. Their motion was not just about stalling, it was about strategy, precision, and preparation. With the complexity surrounding the case, the extension seemed to them like a vital pause to get things in order. On the other side, attorney Brian Friedman made his position clear. He wants this trial moving forward, not backwards. His stance remains firm. No unnecessary delays, no detours from the scheduled path. Now, while courtroom decisions were unfolding for Baldoni, Blake Lively was facing challenges of her own in a very different arena. And though these battles are worlds apart in nature, the emotional weight they carry often feels the same. We'll unpack what happened with Blake in just a moment, but first, let's stay with Baldoni's legal drama a bit longer. It's far from over. This case continues to unravel with a sense of urgency and quiet intensity. Despite previously emphasizing the importance of keeping the trial on schedule earlier this week, attorney Brian Friedman made an unexpected move. He requested an extension of time from the court. In his communication with the judge, Friedman explained that Blake Lively, Leslie Sloan, and Ryan Reynolds were all in disagreement regarding the proposed delay. They weren't on board with pushing back the timeline. His request, he claimed, was rooted in fairness and a commitment to the court, an effort to maintain his original promise of keeping everything aligned with the March 2026 trial start date. But that promise met resistance. Judge Lyman responded with clarity and finality. He denied Wayfarer's motion to extend the deadline for filing a second amended complaint. In his written order issued today, he addressed the core of the matter: Wayfarer's request for additional time to allow all parties to respond to interrogatories, amend pleadings, or potentially bring new parties into the case was not supported by sufficient cause. Referencing precedent, Judge Lyman pointed to the case of Furry Puppet Studio versus Fall Out Boy. He noted that the Wayfarer team had already been aware for several weeks of the issues raised by the opposing parties, issues they believe point to significant flaws in Wayfarer's current complaint. In the court's eyes, Wayfarer had more than enough time to respond accordingly, and their inability to act sooner simply didn't justify further delay. And here's the key detail that shaped the judge's stance: the deadline to amend the complaint hasn't even arrived yet. It still stands firmly in place, untouched and active on the calendar. So while Wayfarer hoped for more breathing room, the court essentially reminded them that they've had that room all along. They just didn't use it. April 18th, 2025. A seemingly ordinary date, yet it now marks a key moment in a legal process that's slowly tightening its grip. In federal court, time isn't handed out freely. Under the rules of civil procedure, a party requesting an extension must present more than just a preference or a polite ask. They're required to demonstrate what the law defines as good cause. That responsibility lies entirely on their shoulders. And what exactly qualifies as good cause? It's not vague. The court outlines it precisely. Good cause exists only when the delay results from an understandable error, excusable neglect, or another factor that reasonably explains why counsel couldn't meet a previously agreed deadline. It's not about convenience. It's about genuine constraint. something that prevented compliance even after all due diligence had been exercised. In simpler terms, even if the intentions were noble, even if they were trying to minimize excess paperwork or limit unnecessary hearings by waiting for the judge to rule on the motions to dismiss, that alone doesn't cut it. The court isn't swayed by tactical patience. Judge Lyman made it clear that's not considered good cause, not even close. Likewise, the argument that they deserved an extension simply because the scope of discovery was large, an overwhelming volume of materials they themselves agreed to, was swiftly dismissed. The volume doesn't absolve them. They had consented to it, knowingly and willingly at the outset. And now the court is holding them to it. They haven't been able to show any valid error, oversight, or unforeseen complication that prevented them from following through on what was scheduled. So, in essence, the judge is reminding them firmly but decisively, you agreed to these terms. The amount may be significant, but it's the amount you signed up for. And now, the expectation is simple. Comply. This presents a deeper problem. For Wayfarer, one they've known about for quite some time. Judge Lyman reminded them that as far back as February, they were fully aware of vulnerabilities within their amended complaint. This wasn't a surprise. It was written clearly in the court record, and the warning signs were there, loud, unmistakable, and legally grounded. Back in February, Judge Lyman reviewed the motion to dismiss filed by the New York Times. Based on its contents, he concluded that the Times had a strong chance of prevailing, especially under the protections granted by New York's litigation privilege laws. Those privileges, rooted deeply in precedent, are built to shield the press. And in New York, that shield is almost impenetrable. Suing the New York Times successfully is not just difficult, it's a legal uphill climb most never complete. Despite frequent lawsuits over the years, very few plaintiffs have ever emerged victorious. The Times has been sued countless times, and one of the most defining cases, New York Times Cumber v. Sullivan in 1964, effectively reshaped defamation law across the country. That case introduced the actual malice standard, a requirement that's nearly impossible to prove when the plaintiff is a public figure. Since then, the courts have rarely, if ever, allowed successful defamation cases to move forward against major media outlets like the Times. The precedent is steeped in history, and the odds are never in favor of the accuser. It doesn't matter how powerful or famous the person filing the suit may be. Even public figures with immense influence, people like Donald Trump or Sarah Palin, have brought high-profile lawsuits against the Times, believing they had solid arguments and strong evidence. Yet even their cases struggled to survive. Despite media attention, legal teams, and public narratives, the outcomes were almost always the same: dismissal. It's a hard reality, and many don't want to accept it. But the truth remains, when you take on the New York Times, especially in the state of New York, you're not just fighting a media entity, you're challenging a deeply embedded legal structure designed to protect free press under the First Amendment. So, when Judge Lyman warned Wayfarer in February, he didn't mince words. Unless they could prove, conclusively, that New York's protective laws didn't apply in this case, their complaint was standing on shaky ground. The motion to dismiss was well crafted, and if left unchallenged, it could easily dismantle their case before it ever reaches trial. And that was the moment when the writing was already starting to appear on the wall. By that point, the cracks in Wayfarer's case weren't just visible, they were undeniable. Judge Lyman had already pointed out that the foundation of their complaint was shaky, and when Leslie Sloan filed her motion to dismiss, she exposed even deeper flaws. Many of the allegations leveled against her were made purely on information and belief, a legal framing that, while sometimes necessary, is often vulnerable to being thrown out, especially if it lacks supporting evidence. That same vulnerability is haunting Blake Lively's case against Jed Wallace. Her claims, though passionately presented, are paper-thin when it comes to hard proof. The reality is difficult to swallow, but it matters. There appears to be no substantial evidence tying Wallace directly to the allegations. Without that, the case against him teeters on the edge of collapse. And the conspiracy claims against Leslie Sloan, just as precarious. The narrative they've constructed feels disjointed, more speculative than grounded. Their attempt to thread her into a larger web lacks the firm stitching needed to hold up in court. Emotion and suspicion alone don't build a legal argument. They need evidence, clarity, and a logical chain of cause and effect. Let's be honest, it's uncomfortable to hear that these cases may not hold. But that's where we are. Every one of the parties, Blake Lively, Ryan Reynolds, Leslie Sloan, and the New York Times, has now filed their own motions to dismiss. And collectively, they've outlined the same thing, a roadmap showing exactly where Wayfarer's complaint falls apart. These responses don't just reject the accusations, they clearly spell out why a second amended complaint shouldn't even be allowed. Yet despite that united front, Judge Lyman had already hinted, back in February, that he might permit an amended complaint. It wasn't a closed door. It was an invitation to regroup, to restructure, and to resubmit their claims with more precision and strength. So the opportunity was there. They knew it. All they had to do was take it. Instead, they waited, hoping perhaps that the court would delay the process, allowing more time before the motions to dismiss took center stage. But now, the tone has shifted. Judge Lyman isn't extending that grace any further. His message is subtle but firm. You had the chance. You knew the rules. I won't pause this clock because you chose not to act. And with that, Wayfarer is running out of options and time. Rather than dragging things out, Judge Lyman made one thing perfectly clear. He has no interest in letting this process linger unnecessarily, instead of waiting to complete the rulings. On the motions to dismiss and then giving Wayfarer time to amend, he essentially told them, "We're not doing this in slow motion." In federal court, judges have the flexibility, months even, to respond to motions. But Lyman doesn't want to take advantage of that timeline. He wants movement, momentum, progress. He's signaling a desire to move with precision and urgency, cutting through the procedural fog that often stalls cases like this. His approach is firm. These motions will be handled quickly, not because he's rushed, but because the delays serve no productive purpose. He's not interested in drawn-out filings, extended waiting periods, or strategic hesitation. The court's some time, in his view, should be respected and used wisely. Now, the message to Wayfarer is unmistakable. Decide by next week whether you intend to amend your complaint. There's a quiet intensity in that directive. It puts the pressure squarely back on them, forcing a decision that might shape the trajectory of their entire legal strategy. And while amending now could streamline everything, saving time, energy, and resources, Justin Baldoni and the Wayfarer team hesitated. They wanted a read from the judge, a sign, some sense of whether their current complaint would survive scrutiny. In essence, they were looking for reassurance before taking the next step. But in Judge Lyman's courtroom, waiting. For comfort isn't a luxury afforded to litigants. He expects clarity. He expects action. And the clock is ticking. Now the judge is drawing a firm line in the sand. He's made it absolutely clear. He's not offering guidance before they make their move. There will be no gentle nudge, no early insight into his thinking. His message is straightforward. You decide first. Then, and only then, will I respond. Back in February, both parties had committed to moving this case along quickly. That agreement now echoes back with weight. In light of that, Judge Lyman's ruling doesn't come as a surprise. If anything, it reinforces his reputation for balance and integrity. When Leslie Sloan asked to delay discovery, he denied her. Now, holding to that same standard, he refuses to give Wayfarer a delay. Everyone involved knew the schedule. They agreed to the timeline. They accepted the rules. And now, faced with the reality of those decisions, they're confronting the weight of litigation, even if the requested documents are voluminous, even if compiling them demands exhaustive effort. This is the nature of high-stakes legal warfare. It's neither fast nor easy, but it's part of the process. A pressure test designed to reveal who's prepared to carry the burden of proof. Many have asked whether the volume of discovery requested is excessive. And truthfully, it is. It's a poishby, staggering amount. But that might not be accidental. If the goal is to push for a settlement, overwhelming your opponent with discovery obligations is a calculated move. It forces them to expend resources, time, money, energy, just to stay afloat in the process. This isn't uncommon. It's a tactic that, over time, wears down even the most well-funded defendants. Every new document request, every interrogatory answered, every dollar spent on compliance chips away at their endurance. And when the stakes are this high, that fatigue can become a powerful negotiation tool. It's not just about what's legally required. It's about the strategy, the long game, the unseen pressure building behind the scenes. And it's only just beginning. This case, at its core, might eventually lead to a settlement. And truthfully, I've been through it myself. Discovery is no small burden. It's exhausting. There are moments where the sheer volume of requests, the back and forth demands, and the endless legal wrangling make you want to throw in the towel. You catch yourself wondering, can this just be over? Can it all just go away? Even if a party insists they won't settle, time has a way of wearing people down. The longer the battle stretches on, the heavier it becomes. Emotionally, financially, strategically. It's not just about facts or law, it becomes about endurance. And keep in mind, the court's March 2026 trial deadline isn't as far off as it sounds. In fact, that pace is blazing fast for federal litigation. I'm nearly 3 years into my own case, and we still don't have a trial date. We only just filed a summary judgment motion this January, nearly 3 years after the original complaint landed in court. So, to get this case into a courtroom by March in 2026, that's ambitious. And Judge Lyman knows it. He's holding firm, trying to ensure that timeline doesn't slip away. Honestly, it's a smart move. If this drags on for years, not only will the parties be drained, but the public will grow tired of the entire saga. So when he denied Justin's request, I wouldn't call that unfair. It's consistent. If they want to amend the complaint again, they'll need the judge's permission. But here's the catch. Blake, Ryan, and Leslie will undoubtedly argue that it's all being done in bad faith, that the plaintiffs have already had ample opportunity, that they've amended once before, that this is nothing more than retaliation wrapped in legalese. And Judge Lyman has already cautioned them. He reminded them weeks ago, make your decision. Don't wait. They didn't act. So if he's starting to lose patience, that's understandable. You can't keep playing the same card and expect a different outcome. For Wayfair and Justin to move forward, they now have to do more than just file papers. They have to persuade the judge. They must bring new information to the table. Fresh evidence, newly involved parties, anything that justifies why another amendment is necessary, and it must be done with precision. They'll need to prove this won't delay the proceedings, that it's not another case of neglect or strategic stalling. They must show that it's not a repeated failure to fix the gaps already flagged. After all, Judge Lyman gave them a chance back in February to amend voluntarily. They declined. Now, months later, they're circling back. At this point, they're standing at a crossroads. They either commit to the complaint as it stands, or take a calculated risk and ask for one more chance to revise. But the window is narrowing, and every step forward now requires more than just argument. It requires conviction and a strategy that won't collapse under pressure. There's a question hanging over this moment. Should they have filed a leave to amend earlier, just to see where it might lead? Because now, if it turns out they knew ahead of time they were likely to amend, then every single motion to dismiss we just went through, might have been a wasted effort. You see what I mean? This could tilt either way, and no one's entirely sure where it'll land. What we do know is that 12B motions to dismiss are notoriously difficult to overcome at this stage in federal court. Judges aren't typically inclined to grant them outright. But here, it's starting to sound like even if the judge does grant the dismissal in full, he's not going to offer them another chance to amend afterward, so the stakes are sharp. And timing is everything. Now, personally, I believe there's still a sliver of a path forward, but only if they return with more than just tweaks. They'd need to introduce new evidence. For example, if they had Blake Lively's actual contract, something concrete that outlines exactly where and how she breached it, or if they presented a timeline of Ryan Reynolds' alleged statements, showing who he spoke to, when he said what, and in what context. That level of detail, carefully threaded into the body of the complaint, not just buried in Exhibit A, could give them a fighting chance. And if they've uncovered new parties whose involvement reframes the case, that could help too. But right, now, real obstacles remain. Section 47.1 is a formidable wall. The litigation privilege protecting media outlets like the New York Times is incredibly strong, especially in New York. Of all the defendants, the Times appears the most protected. At this point, based on the filings and the way this is shaping up, my honest opinion, if nothing changes, the judge will likely dismiss the Times from the case. That's just how these things tend to go. And I understand. People don't like hearing that. But it's nearly impossible to win against the New York Times. Their track record in court is nearly untouchable. So for Justin, this wasn't a good day in court, not by a long shot. He and his legal team, led by the very capable Brian Friedman, now face a pivotal decision. Maybe this was their plan all along, to get a read on the judge's mood, to understand what might or might not fly. But now, they either have to double down on the complaint as it stands, or return to the table with something more, something stronger, tighter, and backed by undeniable facts. And just as the courtroom pressure builds, a new twist emerges. According to a recent report by the Daily Mail, Isabella Ferrer may be quietly trying to distance herself from the entire situation. Now, to be clear, just days ago, headlines swirled claiming Blake Lively regretted stepping into this legal storm, that the pressure was overwhelming. But now, a different tune is being played. People magazine released a fresh piece stating, "There are no regrets at all." According to their sources, Blake anticipated the blowback. She's standing firm, driven not by fear but by a fierce instinct to protect her daughters. If anything were to ever happen to them, or to her, she wants them to know she stood up no matter the cost. To her, this fight isn't just about reputation. It's about legacy, about showing them what it means to confront something that feels unjust. In my view, Blake seems like the type who holds onto her truth with conviction, regardless of countering evidence. Even in the absence of definitive proof, she appears to believe she's been wronged. That's just how some people are wired. They feel the defamation more deeply than logic allows. Meanwhile, a new wrinkle in the story. The Daily Mail now reports that Isabella Ferrer may be stepping back, quietly distancing herself from Blake. That's their claim. Of course, given the rhythm of this case, People magazine may publish a rebuttal within hours, saying that too is baseless. The back and forth is constant, exhausting, and deliberately muddy, according to eagle-eyed watchers on Instagram and Reddit, and notably, a creator named Ellery Rich on TikTok and YouTube. Isabella has been erasing traces of her connection to Blake, posts gone, photos deleted. It mirrors what Colleen Hoover did when the scrutiny intensified. The Mail's insider claims Isabella removed those photos at the urging of those closest to her. Allegedly, Blake wanted Isabella to back up her accusations of sexual harassment, to lend her voice to the claims. But Isabella declined. Why? Because she didn't witness any of it firsthand. The source elaborated. She was incredibly young when she was cast. To her, the entire experience felt like a blessing. She was so immersed in perfecting her role, so focused on bringing Lily to life, that she didn't engage in any of the surrounding drama. And that shows. Isabella's dedication was clear. She studied the book meticulously, worked to understand. Lily not just on the surface, but at her core. That alone already sets her apart. Ironically, Blake is now being criticized for doing the opposite, accused of not taking the same care in understanding the character she was supposed to embody. For Isabella, stepping into a public defense of something she didn't witness would be professionally reckless. She knows how easily careers can be reshaped or shattered by moments like these. From her vantage point, distancing herself isn't betrayal. It's self-preservation. And deleting those photos? That wasn't a casual decision. That was her way of drawing a line in the sand. It's starting to look like Isabella is echoing what Taylor Swift's team has claimed, feeling manipulated, used, and drawn into a situation she didn't fully grasp. She seems to be saying she wasn't fully aware of the stakes and doesn't want to be swept up in the whirlwind of this legal battle. Allegedly, her position isn't far off from what we've already heard. Blake claims 2 other actresses will speak out on her behalf, testifying as witnesses in her first amended complaint. But there's one problem. Blake won't name them. And that's where things get murky. There were only a handful of actors on the set, and Isabella notably wasn't. One of them during many of the critical moments. Her scenes were filmed at different times from Blake's, entirely separate due to the roles they played. Isabella's work was wrapped up before the strike even began, which means she wasn't present for much of what Blake has alleged. So, how can these unnamed actresses, who Blake claims will testify, have witnessed anything if they weren't even around? Then there's Jenny Slate, another name mentioned, but she's refused to speak out publicly. She hasn't supported Blake's side. So, if these witnesses aren't willing to go on record, why is Blake suggesting their involvement in her legal filings? It seems like a strange tactic, especially when she's trying to establish credibility with accusations of wrongdoing that are, at best, circumstantial. The Daily Mail's source paints a different picture of Isabella, that she feels as though she was swept into something that wasn't hers to begin with. If Blake did manipulate her into believing there was something untoward going on, it could backfire, especially if Isabella's deposition reveals she didn't experience any of what Blake claims. This could undermine Blake's entire case, making it look less like a fight for justice and more like an attempt to manipulate others into backing her up. Even more concerning for Blake's defense are the text messages she shared in her amended complaints, which appear to subtly plant the idea that she's been smeared. The timing is off, and the absence of concrete evidence leaves the suggestion hanging in the air, almost as if Blake were planting seeds of doubt in people's minds, long before the facts could back her up. In short, it's all unraveling in real time. Every move Blake makes seems to add more layers of complexity to a case that's already difficult to pin down, and every twist reveals more about the fine line between truth, manipulation, and the public perception of both. As we dive deeper into the case, a growing uncertainty seems to be creeping in. People are starting to question whether they can trust the claims being made. After all, at this point, all we have are allegations, and without concrete proof, it's difficult to decide who's telling the truth. On the surface, it might seem like Belden's case is stronger, but there are several weak points in his argument that make it far from airtight. This battle is not as straightforward as it may appear. Despite the intense legal back and forth, we must acknowledge that the chances of this case ever reaching a courtroom are incredibly slim. In federal court, only about 5% of cases go to trial. The other 95% are either settled out of court or dismissed altogether. And when trials do happen, they take years to prepare for. Just look at the Duggar daughters case in Arkansas. They spent 5 years getting ready for a trial, only for it to be dismissed at the last minute. The reality is, most cases don't make it to trial, and this one, given the current trajectory, looks no different. Judge Lehman, in my opinion, seems to be steering things in a direction that could avoid a trial. His rulings so far suggest that he wants both sides to mediate and settle. The public, too, seems to want resolution. Justice, whatever that might look like, for those involved. And at the end of the day, that means one side will likely have to relent. Settlement talks, I believe, are imminent. Who will initiate them? That remains to be seen. But with the odds stacked so heavily against a trial, it's hard to imagine this case playing out in front of a judge and jury. Now, I want to hear your thoughts on all of this. What do you make of the latest ruling? And Isabella's distancing herself from Blake? Do you buy it? Or do you think we'll see another story soon claiming the opposite? Let me know your thoughts in the comments below. Don't forget to give this video a thumbs up if you found it interesting, and subscribe to the channel so you never miss an update. And of course, hit the bell so you're always in the loop. Thanks so much for watching, and I'll see you next time.